All right, let's get this show going. So thanks for joining. Hey guys, thanks for joining us over here. Let me know if you see kind of capture Jeff over here whenever he's going to join us. I'm moving to a panelist. Looking to hear from Jeff Kahn, our attorney, about recent updates. Something he's gonna repeat from last time, since we had it. That was just when the new contract, the purchase contract launched, and then some other updates as well. And of course, after the meeting, we're gonna share the recordings and any handouts that Jeff might have for us as well. So until it's gonna be here, let's start here with what we have, and I'm gonna pick on Stephanie and the people of Calabasas.
Okay, here we go. So leadership is a matter of having people look at you and gain confidence. If you're in control, they're in control. Tom Landry.
Good stuff.
So, I mean, it's even like parenting, right? The apple doesn't fall far from the tree, right? So it's a matter of, how leadership presents themselves and be able to it enables, right, everyone else. You're giving people permission to succeed at a high level. And if you're keeping your emotions between the lines and the bumper pads on and just staying focused and being in control and being poised, if you will, right? And it gives other people permission to do the same thing. So if you're in control, everybody else around you is in control. But remember, we only can control the controllables.
Exactly.
There you have it. Exactly.
Yeah. I love about this sentence, because it doesn't just say about people looking at you in order to follow you. Like, think about this as an agent, right, who lives in the industry, affiliate, loan officer, what have you. People look at you as an advisor, right? They're looking for someone that they can trust, they can appreciate, and they can basically not just follow in that sense, but how you perceive yourself, that's how other people will perceive you as well, if it makes sense, right? So always be aware of how what is that you project and what you do. We are pretty much leading all the time, right? Jeff, I'm trying to move you to a panelist. I think you have to accept my invitation. Try one more time, hopefully. Oh, there we go. Okay, perfect. Yeah, cool. Stephanie, thank you. And it is football. Well, it was football season, even though for us it never ends, right? So it was nice to get that quote as well. Just shout out to our ALC, our top leadership council group. We had our annual retreat. This time around was in the desert, Palm Springs, about 40 of us from the 4 offices representing the offices, leadership, and you guys, the agents. And it was just a mind-blowing event with a lot of good content and a lot of sharing and good mindset to set the tone for the year. So if you know who your leadership council people are in the office, great. Make sure to reach out to them, to connect with them, build relationships. If you're not sure who those guys are, go to the hub, to your website, the resources website, and click on leadership and see who those guys are and connect with them as well, or ask your TL. Just a fine group of people. So thanks again for your leadership. And from that, let's go to the more exciting stuff, Jeffrey. Jeff, by your background, you're in Encino.
Yeah, that's right. Yeah.
All right, I'm gonna make you a spotlight for everybody, and I'm gonna give you a co-hosting rights so you can share some good stuff with us if you need to share your screen. So let me just
I think I should be able to.
Yeah. Let me know if it works. Oh, there we go. Okay.
You should see that tenant occupied form.
We see that, the form, that's correct, yes.
Okay, and let me see if I can make it a little bigger. There you go. That might be too big. I think I'll just leave it this side. Okay, so you can see that now?
Yeah,
Oop.
click on the, oh, we just lost it for a second.
Yeah.
Click on the green button on the top left of that little box. There you go.
There you go. I'm not sure why it's blue, but let me see if it's going to go away. Okay, here we go.
There you go, perfect.
Okay, good morning, everybody. Today, we're just going to spend a little bit of time going over one new form that actually I went over with you back in December when I spoke to you, but it's an important form, so I want to make sure I cover it again. And then I'm going to cover, you've all taken, hopefully all of you have taken the RPA class, but I'm going to cover a few tips, 5 or 6 things specifically in the new RPA that you need to pay attention to. Go over some of the new laws. I did cover some of the new laws back in December when I spoke with you, but there's some other ones that have come into effect. And then just cover a couple of other areas of interest for risk management. So you're looking at the tenant occupied property addendum, anytime you have a property that's tenant occupied, this is going to auto populate with the form. When you check the box saying it's as a buyer's agent that the property is tenant occupied, then this is going to auto populate and you need to fill this form out. If the buyer is buying the property with the tenant, then paragraph 1 and paragraph 1A, which says tenant to remain in possession, applies. Paragraph 1B doesn't apply. And then the whole rest of the form applies because it talks about, well, if there's a tenant in possession, the buyer has a right to get the lease agreement and the rental statements, the tenant estoppel certificate, et cetera, et cetera, et cetera. But if the buyer is buying the property to move into and they want the property to be vacant at the close of escrow, then it's critical that you use this form and you check item 1B, which says property to be delivered vacant. And then B1 says the property or specific unit shall be delivered vacant without existing tenants. And then the key is paragraph B2, which says if the seller, after the exercise of good faith attempts and subject to applicable law, is unable to remove the existing tenants by the close of escrow, or you could check 5 days prior to close, buyer may cancel this agreement and buyer's sole remedy will be the return of the deposit and buyer's reasonable out-of-pocket expenses for inspection reports and appraisal fees under the agreement, or buyer may elect to proceed with the transaction with the tenants in possession and waives any claim for any other damages or compensation arising out of the tenants remaining in possession. So the key here is that the seller has to make a good faith effort to get the buyer out, of the tenant out. And if the seller does nothing, then this paragraph's not going to help the seller. But if the seller does everything they can to get the tenant out, and the tenant simply does not move, what this paragraph says is that the buyer has a right to cancel the escrow and get his deposit back, or he can close the escrow with the tenant, and he can get reimbursed for his out-of-pocket expenses for inspection reports and appraisal, but nothing beyond that, because we were trying to protect the seller to the point where we didn't want the buyer to sue the seller for all kinds of damages for not being able to get the tenant out when they simply weren't able to get the tenant out after making a good faith effort. So just keep in mind that you need to use this form anytime that you're dealing with a tenant in possession. So I'm going to stop screen sharing this because that's all I had on that one, and then go to another form that I want to screen share. Any questions on that while I'm going to the next thing? Okay.
And I'm watching the chat as well, but nothing,
Okay.
nothing yet. Thank
Okay,
you.
so you should now see the purchase agreement. And one thing I wanted to mention before I get to talk about the things in the purchase agreement, and I don't know if I mentioned it before, but there's a new thing in zip forms, which is called a buyer and seller guide to the new RPA. It was written by the attorneys for CAR, and it's a guide to buyers and sellers on the new RPA. And you can purchase it in the zip form store for, I believe it's $19.99. You can just purchase a hard copy of it, but that's not going to do you a whole lot of good, because the whole point of this booklet is to be able to give out to your buyers and sellers, and you can sign up to get the digital version of this. It's $49 a year from CAR. Now we're kind of but we're kind of talking to CAR about why they're charging $49 a year for this, because personally, I don't think they should charge for it at all, but that's not my department exactly, but we are in discussions with them. But in the meantime, for $49 a year, you would be able to get a digital version of this booklet, which is the buyer and seller guide to the new RPA, and you could send it to your buyers and sellers. I would suggest you send it to the sellers at the point in time you're taking a listing, and I would send it to the buyer at the point in time you're writing an offer with the buyer. And now you've got proof that you have sent them a booklet on explaining thoroughly the residential purchase agreement, both the buyer and the seller, because sometimes they come back later on and say, well, my broker never explained it to me. He just put it in front of me to sign it. I never saw it before, and I signed it. I didn't know what I signed. And this way, you're going to have proof that you sent them a document that completely explained the RPA to them prior to them writing an offer, both buyer and seller side. And when you send it to them, you could say, please review this. If you have any questions, please contact me. We can discuss it. I want to make sure you understand the contract well before you get involved in having to write an offer, blah, 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 blah. So I think it's a really good idea. They're prorating the charge for that. So I think if you buy it now, it's only like $9 or $10 because I think the subscription renews in April or something. But I think it's worth it. I think it's something that shows you're doing your due diligence and explaining things to buyers and sellers. So I think it's a good idea. So with that, we're going to go into a few items in the RPA now. Hopefully you all, I taught this class a couple of times for Keller Williams, so hopefully you've all taken the class. I know there's a recording of it as well, so you can listen to that. But I just wanted to cover a couple of specific areas that are things that I want to make sure that you're fully aware of. And the first one is on page 2 under L2. And I hope everybody can see this. Rich, everybody can see it? Okay, good. So L2 says that it talks about the appraisal. It says the appraisal contingency based upon the appraised value at a minimum of the purchase price or blank. So it now gives you for the first time the option, it gives the buyer the option of filling in an amount there that's less than the purchase price. So let's say the purchase price is $1 million. So you're buying a little shack out in Calabasas for $1 million, or maybe a mobile home, right? So you're spending $1 million or you're offering $1 million, but you're willing to, as long as the appraisal comes in at least at, let's say, 975, whatever number the buyer is willing to go with, that the buyer is willing to put in the rest in cash. So you could check that box where it says appraisal contingency based upon appraised value at a minimum purchase price, and you could write in 975 there. And that means that if the appraisal comes in at least at 975, that the buyer is agreeing to go forward with the sale and putting the additional amount in cash. It also means if the appraisal comes in lower than that the buyer doesn't have to, and they can cancel the escrow and go about their business. Now, if you leave that blank, then you're just with the normal language that says the property has to appraise at the value, at the purchase price. So if you fill in nothing, it's just the normal appraisal contingency where it has to appraise at purchase price. If you fill in a number there, then you're saying the buyer is willing to make up the difference in cash between that number and the purchase price. The second thing I wanted to cover is on page 5. And if you look at page 5, I'm specifically looking at paragraph 8A2, where it says buyer is advised to investigate the insurability of the property as soon as possible, as this may be a requirement by the lender. Buyer's ability to obtain insurance, including fire insurance, as part of buyer's investigation of the property contingency. Failure of the buyer to obtain insurance may justify cancellation based on the investigation contingency, but not the loan contingency. So what does that mean? That means, and you all know that it's much more difficult now to get insurance on properties than it used to be a couple years ago with all the fires and things. So it is critical that the buyer investigate the ability to get insurance, fire insurance, homeowners insurance up front during the investigation contingency. It doesn't apply to the loan contingency. So what it's saying here is, let's say the buyer doesn't do their investigation and it turns out they can't get proper insurance. Now the lender says, okay, if you can't get insurance, I'm not making you the loan. And the buyer says, okay, if you're not making me the loan, I'll cancel based on my loan contingency. This paragraph says, no, it's not the loan contingency that this investigation of insurability applies to. It's the investigation contingency. So you've got to do it during that time frame. It's kind of similar to the language you find in the appraisal contingency, where it says that if you remove the appraisal contingency and you still have your loan contingency, and then the property doesn't appraise, you can't use that low appraisal to get out of the loan contingency, because the loan contingency did not include the appraisal contingency. They're two separate contingencies. So the moral of the story is you shouldn't remove the appraisal contingency until you know the appraisals come in. And it's the same thing with this investigation of insurability. It's saying that this insurability investigation does not tie into the loan contingency. It ties into the investigation contingency. Now, there's one potential exception to this, and that would be, let's say you were able to get fire insurance or homeowners insurance, but when they calculate the amount of what it's going to cost for the premium, the lender then says your buyer is over the limits for their ratios for getting a loan, and they deny the loan based on the fact that you're over the ratios because of the PITI and other things and the insurability, the price of the insurance. That you could still use under the loan contingency because you're not qualifying for the loan based on your ratios. It's different than not getting the loan because you can't get insurance. So hopefully you follow the difference there. If you don't check it out and you can't get insurance, you can't use that as an excuse. But if the insurance puts you over the ratios, that would be a reason that you could use for the loan, because the loan contingency is the buyer's ability to pay the loan back, and that's based on the buyer's ratios and things, not the appraisal, not the insurability of the property. So the next thing I wanted to cover, we go to page 13. And on page 13, you got the definition under K of delivered, delivered, and delivery. And this is like really, really important. The committee decided they want to put some language in this agreement that explains when acceptance is finalized. When do you have a deal? So it says delivered, delivered. I'm just going to read it so and then go through it. It says delivered, delivered, delivery of documents unless otherwise agreed means and shall be effective upon personal receipt of the document by the buyer or seller. So now the question is, what's personal receipt? So they define personal receipt in two ways. The first way says personal receipt means a copy of the document as applicable or linked to the document is in the possession of the party. Well, that makes sense. Obviously, if they have it, that's considered a personal receipt. But the second one is the key. It says that under 2, that an electronic copy of the document as applicable, the link to the document has been sent to any of the designated electronic delivery addresses specified in the real estate broker section on page 16. So that's the key. So we have to look at page 16. And on page 16, you see that whole area there that's fill in the blanks for both the listing agent and the buyer's agent. And you can see there's a place for a designated electronic delivery. And there's a place you can put your email address in. You could put a text number in there. You don't have to put a text number in there. If you don't want delivery to be made by text, just leave that blank. And then there's an alternate line there, which if check says delivery shall be made to the alternate designated electronic delivery address only. So it's up to the listing agent and the buyer's agent to fill in both this section here and this section down here so that when things are delivered, they are delivered to the proper place. And once you send the email to the appropriate electronic delivery place, that's considered acceptance. You've done it. You signed off, you sent it back, and you send it back to the delivery that's mentioned in the purchase agreement. So hopefully everybody follows that, but I'll be happy to answer any questions on that when we get to it. And then I'm going to go back, and then I'll just finish this up, and then I can go back and answer any questions you have. I'm going to go back to page 10, and on page 10, if you look at the bottom here, it says notice to buyer or seller to perform. And there's been a couple of changes in this paragraph from the old purchase agreement. The first change is there's no longer a blank there where you can change the 2 days. It says you can give the party at least 2 days notice. It used to be at least 2 days, and there was a blank in there and you could change it. And sometimes the listing agent or the buyer's agent would change it to like 7 days or something, and nobody knew that they changed it. And the committee felt like that was kind of a sneaky thing to do. So we just got rid of the blank. So basically it's a 2-day notice. You can counter that in a counter offer any which way you want to, but according to the purchase agreement, it's now 2 days. But the key language in here is the last sentence where right down here under E, where it says, if a notice to buyer to perform, a notice to seller to perform is incorrectly delivered or specifies a time less than the agreed time, the notice shall be deemed invalid and void, and the seller or buyer shall be required to deliver a new notice to buyer to perform or notice to seller to perform. So what that's telling you is that if you, as the buyer or the seller, deliver a notice to buyer to perform or notice to seller to perform either too early In other words, the notice has to be at least, can be no more than 2 days before. So if you deliver the notice 5 days before the time frame, it's not valid. And even if you wait 5 days after you deliver it, it's not valid because you filled out the form wrong to begin with, and it's void and you have to give a new one. And if you try to shorten the time frame from 2 days to 1 day, so you give a notice to perform, and even though the contract says it has to be 2 days, you put in 1 day. And we see that quite frequently from sellers and listing agents to get all excited about getting things removed, and they shorten the time frame and they're not supposed to. And if they do that, even if they wait 2 days, it's not valid because it says right here, if a notice to buyer or seller to perform is incorrectly delivered or specifies a time less than agreed, the notice shall be deemed invalid and void, and the seller or buyer shall be required to deliver a new notice. So that's new language that makes it clear that if you mess it up, it's void and you got to give a new one. And then the last thing I wanted to cover is the difference between the statutory disclosures and the right of rescission on the statutory disclosures, like the transfer disclosure statement, the lead-based paint, the natural hazard, the fire hardening if it's required, and the avid of the listing agent. Those are all statutory disclosures, and there's a 5-day rescission period that goes along with that. So once those are delivered, the buyer has 5 days to rescind the contract, and the seller doesn't have to give a notice to perform to remove those contingencies. Those are a 5-day rescission period, and they run out automatically if you don't exercise that right to rescind within 5 days. The other contingencies, which are not statutory things, but contingencies like approval of the homeowner's documents or tenant documents or leases or whatever, those are just contractual contingencies, and those fall into the category of you have a certain amount of time in your investigation or whatever to approve. And if you don't remove the contingency, the seller can give you a notice to perform. And then if you still don't remove them, then the seller has a right to cancel. So there's a different method between the statutory disclosures. And again, that's the TDS, the listing agent's avid, lead-based paint if it applies, fire hardening if it applies, and I missed one. I think, well, maybe that's all of them. And all of those would have that 5-day rescission period that's built in. What's that?
Lead-based paint?
Yeah, maybe lead-based paint I didn't mention again. So that's what I wanted to cover on the purchase agreement. And I'm going to pause. I'm going to go out of this screen share and put up another one. But in the meantime, are there any questions on what I covered with regard to the RPA?
I have a couple of questions, Jeff.
Go for it.
Let's go the first with the statutory disclosures or seller disclosures. Say they're delivered prior to an acceptance. They're delivered in a counter with a receipt of reports.
Yeah, that doesn't work. Oh.
It doesn't work?
If you're talking about waiving the rescission period, they would have to be delivered before an offer is written.
Actually, before the offer was written.
Yeah, once the offer is written, if you put it with a counter offer, the rescission period still applies. The law says that if the statutory disclosures are delivered before the offer is written.
Okay, so, but going forward with my question is, they're delivered prior to an acceptance.
Okay.
Cash offer, 10 days escrow, but the time frame for the seller to return the disclosures isn't changed. What's the time frame that they have in order to return it?
Are you talking about the statutory disclosures?
Yes.
Well, the contract, it doesn't really make any difference about what the time frame is to return it. The key is when it's given. So the return is kind of immaterial. What's important is that from the point it's given to the buyer has 5 days to rescind. Whether they return it or don't return it during that 5 days period doesn't affect their right to rescind. Okay. They just have a right to rescind within 5 days.
Okay. And then my second question has to do with electronic delivery, because that last page is usually filled out by the buyer's agent. Right. So do you recommend that the buyer's agent fill out an email address or a text?
You mean for the listing agent?
For the listing agent, correct?
Yeah, that question comes up all the time. So, the buyer's agent can, if they, now remember that page is after the buyer's and seller's signature line. So there's no problem with the listing agent filling in that information after the buyer and seller have signed because it's below their signature. But as the buyer's agent, if you know the email address for the listing agent, you could certainly fill it in. But as the listing agent, when you get that offer, if you want it to go to a different address, then you have to change that in either on the form or in a counteroffer or somewhere, so that you indicate to the buyer's agent what your approved method is of delivery. So yeah, the buyer's agent can fill it out, but the listing agent has to be awake enough to look at that and make sure it's where they wanted it to go. Because if they don't do anything, that it's filled in saying, here's where we want it to go.
Okay, thank you.
You're welcome. Any other questions on that before I get to the next section?
Real quick, Jeffrey.
Go ahead.
Over there.
There was a question.
Hi, this is Terry Medrano from Calabasas. Good to see you, Jeff.
You too.
Okay, so if you're going in with an offer with 0 contingencies, is the 5 days still in effect?
Yes.
Okay,
The contingency period has nothing to do with the right of rescission. They're two separate things. So if you make a non-contingent offer, all of the contingencies, investigation contingencies, et cetera, are waived, but you can't waive the 5-day statutory period for the statutory documents.
so basically,
Unless it's delivered before an offer was written.
okay, so if it's delivered after the offer is written, you basically have 5 days to
Yep.
cancel, even though you
Yep.
have 0 contingencies. Great.
Correct.
Thank you.
Correct.
We have a question. Go ahead.
So could you go back to, I believe it's area 8, where you talked about delivery?
Can you hear him okay?
Yeah, something about delivery?
Yeah.
Could you reread area K and then maybe back down to 16, but let's deal with K first.
What, you want me to go back to K?
Sure, and just read the delivery part or the
Right.
point.
K, delivery. Paragraph, the key is, it's talking about what personal receipt is, because personal receipt is considered acceptance. And then item 2 says an electronic copy of the document, or as applicable, a link to the document, has been sent to any of the designated electronic delivery addresses specified in the real estate broker section on page 16.
Okay, I thought I heard something about notifying the buyer in that area initially. No,
I'm sorry, notifying the buyer of what?
about the delivery and acceptance.
No, there's nothing there, but there is a thing in here that says by a link. And we covered that last time I did a class, that if you're using a link, the buyer has a right to say they don't want something by a link. And they've got 3 days from delivery of something by a link to say, no, I want it as a regular email, not a link. And if they do that, then you have to resend it as a regular email as opposed to a link.
Okay, clear enough. That's good.
Okay,
Thank you.
did it answer? Are you good? Okay.
Jeff, 2 more questions on the chat. The first one from Alon. Do we need to input the email address twice? Once on the signature page and one on page 13, question mark?
If you're looking at page 16 now, you don't have to input it twice. You can either, under designated electronic delivery, you can put it under your email address. But if you want it to go to a different email address, you could check this box that says, if checked, delivery shall be made to the alternate only. So you only need to put a second one in there if you're using an alternate that you only want it delivered to that one. In other words, it's possible that the buyer's agent might fill in the listing brokers putting their email address in. And the listing agent gets it and goes, no, I don't want it there. I want it to another address. Then they could check the box saying, if checked, and then say delivery shall be made only to this alternate delivery address, not to the address above that the buyer's agent may have put in.
Got it. Second question is from Mr. Rosenberg. Not sure if it's applied to everybody, or maybe it is. He's asking, why does my contract always come up with appraisal and physical inspection checked removed?
Why does it come out that it's automatically removed? I have no idea. There shouldn't be anything that automatically removes the appraisal contingency.
Okay, so
That's something you'd have to check with zip forms.
yeah, okay, yeah. Maybe it's like a tick tech issue, a glitch on your end.
Yeah, there's some kind of glitch going on there because that's not supposed to happen.
Okay, that's good to know.
Okay, can I move back to, can I move
One
back?
more, one more question from Simon, and then you can share screen again. Yeah, Simon?
Okay.
Sorry about that, Jeff.
Okay.
Good morning. Simon Casades, team leader for KW South Bay, Jeff. So quick question, going back to the reference of the notice to perform. I like the fact that, yeah, agents would be very sneaky and would add additional time. So that way the seller, the listing agent, would have to give the buyer more time to release that as a condition. So now moving forward, my question to you, sir, is would that be now added to additional terms if the buyer is requesting more than 2 days to release or to perform the notice to perform?
Yeah, nothing prevents the buyer or the seller from changing that time frame. You just can't change it with a you know, a little blank that was filled in after 2 days. You'd have to actually write it in somewhere, so it's going to be noticed by everybody. So you can do it by way of other terms. You could do it by way of an addendum, and at least that way it stands out as opposed to being hidden in the contract.
Very good. Thank you.
And Jeff, you know, we had a conversation yesterday about something, and make sure you're looking at other terms, because a lot of agents don't look at other terms and they agree to something that is in there. And just a cautionary tale, you know.
Yeah,
just
absolutely.
Make sure, yeah. Absolutely.
We had one that I was talking to Rich about yesterday where an agent wrote something under, there's two places, there's other finance terms and there's other terms. And people write stuff in there. And if you don't happen to look at that, there may be something in there that is binding the seller to something they don't want to be bound to. So I'm looking right now at page 3 where it says other terms. You need to look at that and make sure there's nothing written in there that applies to your deal, because sometimes buyers and buyer's agents sneak something in there. And if it's in there, it's in there, it applies. So you have to make sure there's nothing there that the seller objects to. And there's also a place for other terms, for financing terms right here under G2, under G2, where it says additional finance terms. So you need to pay attention to G2, and you also need to pay attention to R to make sure there's nothing in there, or if there is something in there, that it's acceptable to the seller. Okay. So now I'm going to try to go back to this. Can you see this now?
Not yet.
Oh, uh-oh. I think I forgot to.
Share screen again, maybe?
Yeah, hold on. Yeah, I think I forgot to screen share. So let's try this again. Okay, I got to do this first. Then I got to go to here first.
Oh,
Then I
there you
gotta
go.
to here.
Magic.
Yeah, I'm learning. By the time we get out of the pandemic, I'll have it all figured out. Let's see if I can make this a little bit bigger. Can you see the screen now?
Yes, you can.
It's probably pretty small, right?
Slightly bigger. I mean, hey, by the way, shout out to you for having that, like, you know, 40/40 vision. You gotta be an attorney, right, to be qualified for that.
So where do I, let's see, I need to go to, I think if I go to view,
yeah,
View.
and then I
perfect.
can zoom it.
Zoom.
Oh,
There you
actually,
go, to,
yeah, 150, let's
150.
try 150. Oh my God, it's so big, it's, I need sunglasses. Okay, so everybody can see it now, right? So I wanted to cover a few of the new laws. I actually covered some of the new laws in December, but there's a few that I didn't cover, and I'm going to cover a few that I already covered just to remind you of them. The main one that seems to be creating the most excitement and controversy, et cetera, is SB 9. SB 9 is the law that passed that basically says that a city has to allow someone to subdivide their single-family residence into 2 lots. There are certainly some restrictions on the size of the lots, et cetera, but basically it was designed to allow for more housing. So theoretically, you could take a property that had a single family residence on it. You could put an ADU on that property, meaning you now have 2 properties, and you could subdivide it if you haven't subdivided previously and put 2 more properties on the subdivision. And again, there's restrictions to it. So you could actually go from 1 property to 4. And the cities cannot object to that as long as you follow the basic rules. And they can't make rules that are just overly burdensome, preventing you from doing that. Now, there are certain cities that are going along with that now, and there are certain cities that are fighting it. So it's kind of working its way through the system, but you just need to be aware of SB 9. Please do not give any advice to clients about what they can do with SB9. You just refer them to the city to discuss with the city what the requirements are, or to a real estate attorney. The next one is SB 63, which has to do with fire hardening and defensible space. If that isn't confusing enough for you already, and it is super confusing, they're making it more confusing now, because it now says that fire hardening and defensible space has been expanded to include high and very high fire responsibility areas located within local responsibility areas. Right now, the law is if it's in a high or very high statewide fire responsibility area, that you have to give that form and comply with the law unless you're exempt. But now it's going to apply not only to statewide, but to local fire responsibility areas if they're high or very high. It's not exactly in effect yet because the maps aren't available yet. And hopefully once the maps are available, the Natural Hazard Disclosures Company will have a question that will answer not only whether the property is in a statewide, but whether it's in a local high or very high. And then if it's in a local high or very high, you're gonna have to use that form, which CAR has produced. By the way, that fire hardening and defensible space form likely is going to be divided into two different forms. It's so confusing. We've got so many comments from people that they want it to be two separate forms, so it's not as confusing. So more than likely, come June or December, there'll be one form for fire hardening and one form for defensible space. The next law, which goes into effect July 1st, is the appraisal discrimination disclosure. There's really nothing you have to do except that you are now, starting July 1st, there will be a form that auto-populates with the purchase agreement that talks about appraisals, and that appraisers cannot discriminate against anybody based on the protected classes with regard to appraisals. They found, believe it or not, they found areas of the country where they were doing appraisals, and depending on what maybe nationality or race the buyers were, the appraisal would come in at different numbers, higher or lower, which is insane, but that's what they found, and that triggered this appraisal discrimination disclosure. So it's just a disclosure that's going to attach to the purchase agreement, which your buyers and sellers will sign. There's nothing else for you to do about that, other than to be aware that it's going to be another auto-populated form. The next one is discriminatory and restrictive covenants in deeds. This is also effective July 1st, 2022. You probably have all, from time to time, maybe seen a deed that still has the old, a deed that was done in the 40s or something that still has the old language that says that the property can't be sold to anybody of color or whatever. Obviously, that is not enforceable. It's completely void, but it's still in some of those deeds. And the legislature felt that it was something that should be removed. And so now there's a new law that basically requires the county recorder's office to delete that language when it's found in deeds or other documents that go to the buyer. But there is also an affirmative duty on you as an agent to disclose, if you are aware that that language is in the deed, to disclose it to your buyer. Now, generally, you're not going to know that, because generally you don't really see the grant deed and you don't see the documents that have that language in there. But if you happen to see it and you happen to see that language, then you need to send an email to your buyer spelling it out that that is there, and that they have a right to contact the county recorder to have the county recorder remove that language. So it won't kick in very much, because generally you won't know about it. But if you do, there is an affirmative duty to disclose it to your buyer so that they can deal with it. The next one is AB 838, and it requires the city or the county to inspect a property if they receive a complaint either about lead-based paint or substandard living conditions. And upon inspection, if they find anything, they have to advise the property owner of the violations, and those violations have to be taken care of. So that's a new law that went into effect January 1st. And then finally, there's a dampness and mold booklet that is now new, that is required on all leases done after January 1st, 2022. It will auto-populate with any leases that you do that are new. You do not have to go back and do old leases and use this booklet. It is only for new leases from January 1st onward. You can find it in the Zip Forms library under the EPUB library, but it also auto attaches to every lease you're doing now that's new. So you won't have to go look for it. It's going to auto populate with that. So that's what I wanted to cover about new laws. I'll pause for a minute to see if there's any questions about what I mentioned.
One question from Ed regarding the ASB 9, I believe, he wrote, what if there are HOA rules stating single family only? So I guess to what you mentioned, he just.
Yeah, that's a good question. So that question came up at the CAR legal last week. And I believe the answer was that, let me make sure I can remember what it was, which superseded which. I believe that the HOA could have a restriction on that would potentially supersede the law. I'm not 100% positive. I'll have to look that up to make sure I have that right. But I believe the HOA could restrict that. If the HOA has restrictions on that, then that potentially would block you from doing what you wanted to do. Okay, I'm going to move along to the last category I wanted to cover today, which is some of the risk management areas. I've talked about these before, but I just wanted to mention them because they're popping up again. We were seeing a lot of escalation clauses being used now. You're all familiar, I assume, with escalation clauses where you can write an offer that says that my buyer will pay $5,000 above the highest list price, highest offer made by anybody else. They're perfectly legal. I'm not a fan of them. CAR is not a fan of them. They are legal, however. The problem with escalation clauses is there's two ways to write an escalation clause. The first way is you just put in there the buyer will pay $5,000 more than your offer. The problem with that is that your buyer has no idea what the next highest offer is going to be. So they could be offering $1 million on a property and it gets bid up to $1.3 million, it goes up $300,000 and they had no inkling that was going to happen. And you're basically never going to lock the buyer into that because they're just going to walk away from the deal. They'll use some other contingency to get out. Or you could do it where you put in an escalation clause saying that the buyer will pay $5,000 more than the next highest offer, but not to exceed $1 million, let's say. And the problem with that is that you're showing your hand. I mean, if you put an escalation clause saying, and I'll go $5,000 higher than their offer, not to exceed $1 million, the seller, all the seller sees is, oh, the buyer will pay $1 million. So I'll counter the buyer at $1 million. So the seller doesn't have to pay any attention to an escalation clause. They can completely ignore it and just counter back whatever they want to. So if you've told them up front what your cap is, why wouldn't the seller just counter back at your cap, whether there's another offer like that or not? So escalation clauses, there's a really good quick guide. If you go to car.org and you type quick guide in the top right under search features, it will pop up with the quick guides and you'll see the quick guide on escalation clauses. And it's a really good article that says the right and wrong ways to draw up escalation clauses and what the problems are with escalation clauses. The next item is non-contingent offers. There's also a really good quick guide on that. The one area that I have the biggest concern about is an offer made non-contingent, and somebody mentioned it earlier. What if you have a non-contingent offer and no investigation contingency? It's one thing to have a non-contingent offer with no appraisal contingency and no loan. I mean, maybe you have a buyer that says, you know what? I know I'm going to get the loan. I'm pre-approved, and I have a relationship with this lender. I absolutely am 100% positive I'm getting the loan. I don't care about the appraisal. I want to buy the property. That's still a little risky, but at least the buyer knows what they're getting into. But when they waive the investigation contingency, they've got no idea what's going on with the property. And you may have a seller who doesn't know the full condition of the property. What if there's a foundation crack that would have been discovered by an inspector had he done an inspection? The seller doesn't know about it. Escrow closes, the buyer waived their inspections, they find the crack and they try to sue the seller. And the seller's defense is, you can't collect against me. I didn't know anything about it. Yeah, there's a crack on foundation. I didn't know it. So what's your claim against the seller? They're not guaranteeing the property's perfect. They only have to disclose what they know. And if you waived your investigation contingency, the inspector who may have picked that up, you never had the right to have the inspection. So I think it's a terrible idea to waive the inspection contingency. If they're going to waive it, I think it is pretty critical that you either use the sample letter in the CAR library that says acting against the advice of broker, where you tell them that, in waiving this, you're acting against your advice, even though there's a little bit of language in the contract that already says that. I would strongly recommend using that. Or if you don't use that, at least send them an email that says to them, you understand that by removing your investigation contingency, you are not fully being able to investigate the property and you're putting yourself at risk that there may be a problem with the property after the close of escrow. So make sure that you have a paper trail that covers that, especially for waiving the investigation contingency. If an offer is presented to you as a listing broker and a seller, my personal opinion, and it's non-contingent, I would counter back in a 5-day contingency period for the investigation just to play it safe, because if there's a problem after escrow, whether the buyer has a good case or not, they're going to sue everybody. So rather than that, let them have their right to do an investigation, and then if they don't do it, that's their business. But I would actually counter it back in just to give them a short time frame to their investigation contingency. The next item is non-standardized offers like Zillow and Rex offers and some of the other offers where they use their own offer form. Those offer forms often have language that are not beneficial to your buyers, that they're definitely weighted towards the seller. I prepared in all your offices should have a form that we developed about 6 months ago. That's a non-standardized disclosure form. If you don't have it, I can send it out to Rich and many, but I have sent it out previously. And it's a form that basically says to the buyer, when you're dealing with like a Zillow offer or a Rex offer, that this offer is on a non-standardized form. It's not a CAR form. You're advised to check with your own real estate attorney about what rights you may be waiving, because a lot of these offers, they waive the right of the buyer to go after the seller after the close. They shorten the time frame in which the buyer has a right to do it. They minimize how much you can sue for, et cetera, et cetera, et cetera. All these things are things that are not to the advantage of the buyer. And you can't give the buyer legal advice other than to tell them, this is not a standard form. You need to have this checked out by your own attorney. And then if they do it, great. And if they don't, at least you advise them of that, because there are definitely things in these third-party deals that are offers that are not good for a buyer. There's also another form.
Also, just to piggyback on that one thing as well, it might be also applied to maybe new homes. If it's like usually like a small tract development that
Exactly.
that have their own forms.
Exactly.
But what would be your input regarding there's out there a lot of those 55 older or what have you development that they're using their own forms as well.
Same thing. Anytime. Yeah,
Same
same thing, Manny. Anytime it's a non-standardized form, they need to be advised to, and when you're dealing with a new homes, a lot of times they may not use the CAR new home form. They're just going to use their own form. And there's stuff in there that they've developed that weighs to the advantage of the seller and is not as good for the buyer. So whether they check with their own attorney or not is their business, the buyer, but you should be advising them that they should do so. So that non-standardized form would be used for new homes too, when the developer has their own form. The next item is referring vendors to clients. We also developed a form for that. We've had some problems with, especially with agents recommending handymen to buyers or sellers. And, there's a law now that says that a handyman who's not licensed can't do work. I don't know if it's over $500 or $600. I think it might be $600 now. And that there's always handymen out there that are doing work for more than that. But when you recommend that handyman and they do a couple $1,000s worth of work and it goes south, that potentially is going to put you in the bullseye for getting dragged into a dispute. So we prepared also a second form that's a notification to a buyer and seller that if you're recommending vendors to them, that they need to vet the vendors and make sure that they're adequate for whatever purposes they want to use them for. So there's those two forms, and I'm pretty sure Manny and Rich, you should have those available to you. And there's there's two more things I wanted to cover. I wanted to mention just do not call and do not email. Those are popping up. I sent out a notice to everybody with Keller Williams a couple of days ago. There's a guy named Jorge Rojas, R-O-J-A-S, Jorge, J-O-R-G-E, Rojas, R-O-J-A-S. And I sent the notice out to all the managers. He is a professional litigant litigating. As soon as you call him, he sends you a letter and demands money because you called him, especially if you use an auto dialer like you're cold calling. You have no defense to that. I mean, it's against the law. And when you make that call, you are subject to a $500 to $1,500 penalty. We just settled one in a different office. We had to pay $1,500 because there's really no defense. And this guy is filing lawsuits in U.S. district courts. A lot of these guys are filing it in small claims court. This guy's filing it in U.S. district court in California. and it's a pain. You do not want to get involved in that. So the guy's name, and hopefully Rich and many have already put it out to all the agents, the name of this guy, the guy's telephone number. Make sure that telephone number is removed from all your lists. Otherwise, you are going to get dragged into this, because this guy, this is what he does for a living, I think, because he sent this letter out within a half hour of the phone call. I mean, so this is not a guy who's just casually doing this. This guy apparently is doing it for a living, and he's not the only one. There's a number of guys out there that are making a living doing stuff like this. And their theory is that they're the good guys, that they're protecting the system. But the fact is they're basically abusing the system. But you as an agent aren't supposed to call somebody who's on the do not call list, and you're not supposed to use an auto dialer to call somebody. And if you're doing it, you're violating the law and you're going to be found guilty. The next thing is the power of attorney, that it does not survive the death of the maker. So if you have a deal that's in escrow and before the seller signs the grant deed, they die, that seller dies, that deal is not going to be able to go forward. You're going to have to go through probate. However, if the seller signed all the documents they had to sign before they died, like the grant deed and everything else, there are escrow and title companies that will go ahead and close the escrow, even though the person has died, because they've already executed the documents. You just have to check with the title company. Also, just a note that powers of attorney are not normally any good in trusts. When you have a trust, you have a trustee. And there's a trustee, and then if the trustee dies or is incapacitated, there's a successor trustee. There's no provision normally in a trust for a power of attorney. The whole point of a trust is to have a trustee or successor trustee handle the affairs of the trust. And so if a trustee has a power of attorney, he's not going to be able to use that power of attorney unless the trust specifically says that a power of attorney is okay, and almost no trust says that. So just if you're dealing with a trust and a trustee says, well, I've given a power of attorney to so-and-so, that's more than likely not going to work. And the last thing I wanted to mention that actually Rich and I discussed yesterday was the use of the seller or buyer intent to exchange supplement, the CAR seller intent to exchange and the CAR buyer intent to exchange. When your buyer or seller are doing a 1031 exchange, a lot of times I'll just see language that says buyer to cooperate in seller's 1031 exchange, or seller to cooperate in the buyers. And that's fine, except it doesn't cover all the potential issues that can come up with a 1031 exchange. So if you look at the form, the CAR form for seller or buyer's intent to exchange, there are checkboxes in there that determine what happens if the exchange can't happen. Is there potential for an extension of time that the buyer or seller can have if they need more time for it? Or is the escrow just going to cancel if they can't do it? So there's different options that are available to the buyer and seller. And if you don't use that form, you've left all that up in the air and nobody knows what it means. And basically, if you don't use it, then there's no ability for a buyer or seller to delay the closing or to cancel based on their inability to, or their delay in being able to do 1031 exchange. They're stuck with the fact that they don't have that language. So anytime you're doing a 1031 exchange, make sure that you use the 1031 CAR, either buyer or seller intent to exchange. So with that, I've come to the end of what I wanted to cover. So I'm just here for questions now.
That was a great 10 minutes overview, Jeff, so far. Fantastic. Quick question for you in the chat. That was a joke, by the way. On the chat, sorry, hold on. Jay had a good question over here. I'm trying to, okay. It says, if a person registers on my website and clicks the privacy or other disclosures, etc., can we call them, or we still have to check them on the do not call list?
Now, what are they checking on your website?
Privacy or disclosures, or, if you click on this, you agree for me to do that, something like that.
Yeah, I mean, you'd have to see the language that's in the website. Generally, language in a website is not going to supersede the fact that somebody's on a do not call list. The only people you can call on a do not call list are people who have given you written consent to do so, or somebody who is a client of yours, meaning you've had a business relationship with them over the last 12 months. And just having them click on something on a website probably is not going to do that unless there's some language in there that is more broad than just a statement about the website itself.
Got it. Okay. Question from Calabasas. You can unmute yourself for a second.
Hi, Jeff. This is to clarify the statutory.
I know if the seller gives them to the buyer's agent before they get the offer, the 5 days is not in effect. But what if the buyer writes the offer and the date and time is before they actually received it, even though the listing agent doesn't have the RPA?
Yeah, so that's a interesting question. So the law basically says that the rescission period applies if the disclosures are given to a buyer before an offer is written. So in
So
your,
if they write it, okay, I'm writing it at 12 o'clock today. The listing agent sends me the disclosures at 2, but the listing agent doesn't have anything yet. And I send them everything in the evening. The date on the RPA actually is before they receive those disclosures. Do they have to rewrite? Do we have to, as listing agents, make them rewrite the RPA with the time after they receive those disclosures?
I don't think that's going to make any difference. I think once they write the offer, there's going to be a 5-day rescission period. So if they wrote an offer at noon, and even though they haven't presented it yet, and you then send them the disclosures, you're still going to have that 5-day rescission period because they wrote the offer before the disclosures were given, and rewriting the offer won't do you any good because they already wrote the offer.
Oh, okay. So that's interesting. Okay.
Yeah.
Thank you.
Good question. Thank you. There's Rich, if you can pick up later on directly with Alon, his question on the chat. It's more, something specific. So if you can give advice on that one. Jeff, straight from Encino, Hawaii. Thank you for the insight. Always good stuff. Even if you have nothing to add, it's just a lot of things changing all the time. So great presentation. Thanks again for your time, as always.
Thanks, Manny. Thank Rich. I'll see you guys all next time, and enjoy the rest of your meeting and the rest of your week.
Thank you, Jeffrey.
Take care, everybody.
Thank you, Jeff.
Later.
There we go. And again, we're going to share some content with you guys, whatever was the handout, etc. And of course, this recording as well later on. Let's see what we have. A few minutes left just to go over a few things. And again, if you have more questions, reach out to South Bay, to Simon, broker questions, etc. And Coastal Calabasas to Rich, and LA Harbor to Gordon over here, or Sal. If you have more questions about that. The shout outs to our offices. We had fun parties, team meetings the day of. Good times, everybody. Thanks for whoever showed up in the offices and just celebrated over here. Good times. Thank you for participating. Promote a few sessions. Thursday, I'm going to lead this mastermind with Esmeralda, Luisa, and Cheyenne over at our various offices. It's going to be a virtual Zoom. You can show up to the office as well and just sit like we're doing right now and zoom into the screen. We'll talk about social media marketing, how they're doing it, what they're doing, what's working, not working, and just brainstorm some ideas with everybody. So that's Thursday at 2 p.m. Rich, any specific items on this class next week?
Any specific one? I'm sorry.
Just to promote this class, you're going to go over what?
It says statutory disclosures for residential properties. So this what Jeff covered today. I'm going to go into a little more in depth about what those statutory disclosures are.
Great. Okay, so that's on the 23rd.
Can I say one thing about it?
Yes, please.
And Rich will be live in the Calabasas office. Woo! So there you go. Can't wait to see you, Rich.
Thank you. And I will be live just at Coastal for their office meeting on Tuesday. So
yes,
let you know that. Okay.
We gotta share.
Exactly. I have to share the love.
We gotta share. And yes, it's gonna be the 23rd, gonna be on a Zoom session as well, and recorded. Awards, we have tomorrow the South Bay Awards, the 16th at noon, right? Led by Simon and team, and Pedro LA Harbor, we have it on the 23rd. It's next Wednesday offsite. Excited about that. Family event, we're gonna probably in next couple of days, right? Every office is gonna promote through the team leaders. We're gonna promote like a email with itinerary of the watch party. So if you cannot physically attend the event or didn't plan to, unless you purchase your own online access, you can spend the entire weekend home, wherever you are, watch all those events, which I recommend 1000%. If you do want to come to the office, we are going to host some watch parties, and we're going to have, every office is going to have their own kind of pick on what they want to kind of present, right? So quick kind of overview. Stephanie Calabasas, what's the plan for you guys?
I beg your pardon?
What's the plan for you guys for this weekend host party?
Yes, so we are not having one here, and I'll tell you why. We are having a special day next week with the recording, so they can come in and watch. We'll have breakout sessions. We'll have the Gary Keller, the keynote speaker, and so we'll be able to make a day of it. So we're having a watch party when we get back from family reunion. Got it. Awesome. Hey, Coastal?
Yeah, our party's gonna be better. Just kidding. Just kidding. No, so we are planning a couple different things. We are going to be watching in person on Monday, I believe, right? Yes, Monday. Here in the offices. So just stay tuned, you guys, for more updates. We'll have fun stuff. Again, breakouts, masterminds, and things planned. I did learn many, and I do want to plug this. I did learn with Family Reunion that on one of the first days, they are separating the tracks so that you can go to classes and masterminds that are going to be specifically for you and what your business is, AKA solo agent, AKA team, AKA, person with an assistant. So that way you're making sure that you guys are getting that info. So I loved that. And that was fresh and new this year. So I want to make sure everybody knew that.
Awesome. Thank you. Coastal, South Bay?
Well, I think South Bay is going to have the best. We're actually going to have catering. Just kidding. Just kidding. We're doing the same thing here as well. So anyone that likes to join us, it'll be here in the training room as well. So thank you.
Thank you, Simon. And Mary, here in Pedro?
Yep, same thing. So we are gonna launch here in office as well.
Okay.
Yep.
Okay, awesome. So again, the next couple of days, each office is gonna get an invite on what's happening. Talking about parties. Can't wait to run to the field. Who's with me? All right. Well, so if you crushed it in 2021 and you ranked in top 100 producers, you're up for a treat very, very soon. You already know who you are because you got the invitation that followed the 2021 or this year's awards events. And super excited about that, again, special treat. And what makes it even more special is that the first season for the SoFi took place, 21-22, right? And the Super Bowl was in the SoFi in 22, and a home team, right, won the Super Bowl as well. So to be there, not too long, short after these events, that's going to be incredible. So guys, this is your year, crush it. So you have no idea what's going to happen next year. We have a nice treat. Quick update on Bold. Stephanie, we're going to launch on the end of March, right? 31st?
Correct. The first step is March 31st. It's going to be, well, we'll give you all the details. It will be virtual on this particular Bold, but we have David Jones, who's been doing it for the last couple of years for us, and he's off the charts, amazing, and always great production. that follows. So we're super excited to have him back and everyone come on board for the journey, right? Let's be bold.
Let's be bold. First step, 31st, and you know, all throughout April and graduation on May. So that is the prime time right now to focus on how to get more listings and how to convert buyers to be more, you know, more motivated and purposeful. So this is it. This is the first one, and then the second one's going to be kind of closer to October or so. Most likely going to be a live event, in-person event. Holly, Sam, anything more about that? Bo?
No, just make sure you register for first step. Remember, it's free. So if it's something you're considering, not sure about the value, talk to the many people in your offices that have graduated Bold and seen the results from it. And then join us for first step at the very least.
Holly, any other thing, anything else you wanna share besides that?
No.
Okay. Simon?
Just to add, you know, as Holly was saying, you know, first step is obviously free, but also we have an incentive. So if you do take the full Bold, you know, on your first 2 or 3 transactions, you'll get reimbursed. So practically it's free.
Cool, thank you, Simon. And you did have something else to share. Do you want to share right now, or are you good? Okay.
No, I think we're good. The attorney, this is the first time that I've heard Jeff, so great stuff. You know, I was going to touch a little bit of non-contingent offer, but he said it very clear and concise. So no worries. We're good.
All on spot. Thank you, Mary.
No, I'm good too. Ready for goals as well.
Cool, Stephanie.
I'm speechless.
Well, it's because there are parties going on this weekend. We're gonna talk about that, okay? All good. All right, guys. So thank you. Thanks for being here. Thanks for attending our virtual all offices event. And with that, happy Tuesday, everybody.
Happy Tuesday.